Hi everybody, hope everyone's doing good today. Welcome to my YouTube channel. This is my Facebook page, Sue Your Lender, Fight Foreclosure and Mortgage Fraud. If you're looking to fight back and save your house, you can join us there. We collaborate together and help each other. Today we're going to talk about some things, interesting things. One of the things I wanted to go over with you guys today was how to look for other cases so you can read about how their case went. And one of the best places to do that is in New York City. Now I go to this website here. You can see the address, iapps.courts.state.ny.us. You go to the search, right here, case search. It's interesting because you can look up party's name. In this case, let's just do a test. Let's do defendant. Let's type in Wells Fargo. So Wells Fargo is the defendant, which means that the homeowner is going to be the plaintiff. So let's see what we can find. Let's go down here. We got to go to the I am not a robot. Search. Oh wow, look at all these cases. Alright, so we know we have lots of cases we can look through to see how they went. New York is a good place to look because they will show you all kinds of stuff. So let's just see here. Let's find something where Wells Fargo is a trustee. Or here we go, Wells Fargo home mortgage on here. Let's try this one. Let's see what we get. Okay, not much with this one, right? Not really worth looking at. You want to look at cases where the homeowner actually filed. Whoops, let's see. Resubmit the form. Here we go. Try this again. Alright, let's try a different case. Here we go. Wells Fargo Bank as trustee. Okay, this looks like it's not going anywhere. Let's find one that is going somewhere. Okay, here is a case that you can look at. It started in 2009. Foreclosure. Okay. So here you can look at the summons and complaint, a reply, answer and counterclaims, notice of appearance, order to show cause. Alright, well, this case has got a lot of information in it, huh? Decision and order, change attorneys, notice failure to comply. You can see all these things. Order granting summary judgment. Let's see at the very end here. Let's see how this case ended up. Notice of appeal. That means that it was appealed. That means that probably the homeowner lost. Let's take a look at this appeal. Is it going to show me? Ah, look, here we go. There is appeal. Okay, so if you want to research how these cases go, as far as, you know, in the system and stuff, if you're in New York, this is probably good for you. I'm not sure about other states, but it does give you some case law if you're in New York. Just so you know, this is one place you can search. The other thing I wanted to go over with you guys is there's a cool site where you can get an amortization schedule. There's a calculator. It's at bankrate.com. I put the link on my Facebook page. If you want to just go there and find it, that's great. Otherwise, you can just type it in your browser, bankrate.com, mortgage calculator. And this is pretty nifty because you just put in the terms of the loan, loan amount, interest rate. It'll come up over here what your payment will be. Now if you go down a little bit, you'll be able to see the actual amortization schedule. You'll see how much goes to principal, how much goes to interest, and your remaining balance. So if you made a spreadsheet showing what your lender is currently doing, you can compare that with what should have happened. And you can also find problems in the mortgage that way as well. As time goes on, if you notice with this kind of schedule, the principal payment should go up and the interest should go down. Let's look at, if it's a 30-year loan, it'll be paid off in 2053. You can see by the time that happens, you're paying $635.02 in principal and only $16 in interest, you see. But sometimes those mortgage servicers, they don't charge you the right amount of interest but if you have a schedule like this, you can determine exactly how much they're supposed to charge you for interest, how much for principal based on your balance. So it's pretty handy to double check to see if your lender is actually crediting your payments correctly, because we all know that they don't usually do that. The other thing I wanted to go over with you guys is the case called Jasinski versus Countrywide Home Loans. This was decided in 2015. It's a pretty interesting case. A lot of us can relate to going through what they went through. Basically what happened was they rescinded the loan. They had 3 years to rescind the loan, which they did. And this is a Supreme Court case. So if you had Countrywide and you tried to rescind your loan, you can actually use this as precedence. It says here, according to the Truth in Lending Act, a borrower has the right to rescind a transaction by providing written notice to the lender within 3 years of the transaction. Under the clear terms of the statute, the borrower need not actually file a lawsuit within that period to exercise his right. Interesting, huh? I thought you guys would think that would be interesting. So this is another case that's on my Sue Your Lender site. If you wanted to look at that, it's pretty interesting. The other thing I wanted to let y'all know about is something else you should read. It's at the Consumer Financial Protection Bureau, the CFPB as we call it. And you want to look at Regulation Z. And then under Regulation Z, they do have prohibited acts and practices for certain requirements for credit secured by a dwelling. In other words, a mortgage. And they tell you the definitions of a mortgage originator, etc., and they tell you what acts are prohibited by them. Table funding, servicing, real estate brokerage, third-party advisors, meaning of creditor, meaning of broker. All these things are important to read. If your loan has not, if they haven't followed the law, and when they process your loan, if they do anything underhanded, which they can't necessarily do some of these things, then you copy and paste this and put it in your complaint, because it'll be helpful if you do that. So I just thought you guys would want to see this. Maybe y'all have seen Regulation Z. Federal Truth in Lending. If you have a federal lawsuit pending in court, you want to use some of this against them. They have all kinds of information here that mortgage servicers, mortgage lenders have to abide by, but they don't. We know they don't. Pyramiding late fees, things like that. All kinds of things. Prohibited payments to loan originators, things like that. Another cool website, guys, for you to look at is Georgetown Law. Georgetown Law Library. It's free, so you don't have to join or pay anything. They have some interesting things here. They teach you things about the law that you would have learned in law school, like basic case citations. They also have tutorials. And if you want to look at their tutorials, you just click on that and it comes up. It explains what you need to see in layman's terms. And some of it's kind of interesting. But let's see. Let's just play a little bit so you guys can see
Legal citations can be baffling to the uninitiated, but they actually contain a lot of valuable information. This tutorial will help you decipher and construct case citations. Note that all citations can become complicated in various circumstances. This tutorial will only cover the basics. At the end of this tutorial, you will have the opportunity to go directly to other tutorials that review statutory citations and law review citations. Cases generally fall under Rule 10 of the Blue Book. The first part of a citation should be familiar to anyone. The party names separated by a V to indicate versus. The party names should either be in italics or underlined. Be consistent and always use one or the other in the same document. Following the names is the volume number of the reporter. In order to maintain consistency between print and online legal resources, the volume number is still used in citations where the case is printed in a book. The same goes for the name of the reporter, which follows the volume number, and the page number. Lastly, in parentheses, you will find the jurisdiction and year of the opinion. If you are referring to a specific piece of the opinion, such as a quote, you should also note the page or span of pages where that piece is found. This is called a pin cite, or pinpoint citation. Each piece of information in a citation conveys crucial information to your audience. The names of the parties act as a recognizable and memorable piece of human information about the case. The name of the reporter and the accompanying volume and page numbers enables your reader or editor to look up your source material easily, no matter whether they are working with printed volumes or electronic databases. The jurisdiction and date enable your reader to quickly evaluate whether your source is mandatory or persuasive and how old or recent it is without even looking at the source material. When you have cited a case once, you do not need to continue to write out the full citation on every subsequent mention per Blue Book Rule 10.9. Instead, you can use the short form of the citation in subsequent mentions. This form only uses the first party name or second party if the first is a governmental entity. The volume number and reporter abbreviation and the specific page or span of pages you are referring to complete the citation. There may be times when you want to cite a case that has been subsequently overruled, affirmed, or otherwise reviewed by a higher court. In that case, you need to include information about that subsequent activity in the citation itself. This is covered in Blue Book Rule 10.7. The abbreviations for explanatory terms and phrases appear in Table T8. Denials of certiorari or rehearing are generally not noted unless significant. Again, consult Rule 10.7 for guidance in specific instances. Some cases may be found in more than one reporter. For instance, a state case may be found in the reporter for that state and also in the reporter for the region. There are times when you should cite to both of these reporters. This is called parallel citation. Rule 10.3 notes that for court documents, local rules control which reporter or reporters should be cited and whether or not parallel citation form should be used, but it also gives general guidance for law reviews and general legal memoranda. Sometimes cases have not yet been printed in official reporters, but are still found in online databases such as Westlaw and Lexis. Those that are going to be printed are referred to as pending. Those that will not be printed are frequently referred to as unreported. Cases published in the Federal Appendix are still considered unreported. Others are found in Westlaw and Lexis only, and not in any print volumes. Certain jurisdictions will not accept unreported cases as authority at all, so be sure to check local rules if you are considering citing an unreported case in a court document. Rule 10.8 governs the citation of pending and unreported cases.
There are other tutorials you can look at Georgetown Law Library. We as you can see, there's all kinds of cool things you can look at. These might help you. Just kind of go down here so you can see what they are. And there's other stuff you can look at on their website as well. They have, like, you go to the main page of the law library. This is the main page. And you can see there's databases, research help, tutorials, frequently used databases, U.S. law, all kinds of good stuff here, guys. Stuff that'll help you when you're making your motions and stuff that you have to file in court. Make them better, make them so they don't expect us to do it as good as a lawyer, but we have to learn to fight back. I hope you found this interesting and useful, guys. Please subscribe, it helps me, and I'll see you guys with the next video. Y'all have a great day.